Okay, Paul, it's 5 o'clock. So I want to welcome everyone to our latest ATPE webinar, the latest on COVID-19 on campus. My name is Kate Johans. It's my honor to serve as the Marketing and Communications Director here at ATPE. And I'm excited to be here this evening with ATPE Managing Attorney Paul Tapp. We have structured this webinar a little bit differently. I'm going to go ahead and stop the share. And what we're going to do this evening is answer your questions. We had quite a few submitted, and we also will be taking your questions through the Q&A panel. So please, as we go through the questions that were submitted by our attendees, if you think of something else, please type it into the Q&A and we will address those. If they fit in while we're talking, I will address them, but if not, we will add them at the end and do a full Q&A. So Paul, is there anything you'd like to add before I start peppering
thank you. Thank you all for joining us this evening. Hopefully we will be able to share some helpful, useful information to you.
Well, Paul, I went through the questions that were submitted and I have them loosely grouped into 4 categories. So I'm going to start with the category that is perhaps most obvious because it's the most tangible, and that is masks. And I'm wondering, what is the latest on the mask mandate battles in court?
They are ongoing. At this point, we've had various courts rule on various specific issues relating to various specific localities. And the Texas Supreme Court has ruled on a couple of technical issues relating to particular bits of litigation. Basically, what all that means is we don't know. We don't know what's going to happen yet, and we're honestly not going to know for some time. As we posted before, TEA even has on their website that because of an ongoing litigation, they are not going to be providing any guidance until that litigation is done. So at some point in the future, the matter will get to the Texas Supreme Court, and a final decision will be made as to whether Governor Abbott did in fact have the legal authority to prohibit local mask mandates. But until that point, we're no real closer to knowing what that ultimate answer is going to be than we were a few weeks ago.
And so is the Texas Supreme Court the last stop for this, or could it go beyond the Texas Supreme Court?
That's a very good question. It is likely the last stop for this, because the question as to what authority the governor of Texas has is likely going to be ultimately answered by the Texas Supreme Court. You know, us lawyers, we do like to make novel arguments, so somebody could possibly try and take it somewhere else. But at this point, I think, honestly, it probably will get decided by the Texas Supreme Court.
Okay. Well, so in a world where there is this legal ambiguity, we did get several questions about that. So one of our members asked, if I work in a district that has a mask mandate, so they've instituted a mask mandate despite the governor, and the educator does not want to wear a mask, what should they do?
Well, first of all, it depends on why the educator doesn't want to wear, whether it's I don't want to wear a mask or for some reason I can't wear a mask. It's understood and always has been understood that if there is a legitimate health reason why an individual person can't wear a mask, that needs to be taken into account in the Americans with Disabilities Act. So set that aside. If it really is just a matter of I don't want to, though, there's no health issue, it's just they're uncomfortable, or for whatever reason individual has that they don't want to wear a mask. At this point, and while this has been going on, we have been advising people that because we don't know how this litigation is going to end up, the safest thing for people to do is to follow the local mandate, because not following the local mandate is honestly not following local policy. As I'm sure everyone knows, not following your district's local policy can result in negative employment action. There could be a defense saying, well, you didn't have the authority to require that in the first place. But again, not knowing how litigation is going to turn out, we don't know how strong that defense is ultimately going to be. So for that reason, just for the sake of reducing risk, and again, it's going to be ultimately an individual decision, but for reducing risk, we've been telling people the safest thing to do is to go ahead and follow that local mandate.
We did get a request that we raise our volume, so I don't know if that's something we can control on our end, or I don't believe so, but here, I'm going to try to.
I will tell you, I got mine at 100%. So.
Okay. I will talk a little louder. Thank you, everybody. Great. Thank you, Paul. Next question is kind of the flip of that. And that is, not really the flip, but if you work in a district that has a mask mandate and your students are, if you have a student who's refusing to wear a mask, what options do you have?
The best thing to do is go to your administrator and see what do they expect? What are the expectations for a student who isn't following the local mandate? And I will tell you, those are all over the board from what we've seen from different districts as far as enforcing the mask mandate for a student who doesn't. So you want to go to your administrator to see what should you do. Is this considered like a dress code violation? Is this something else? Is our district actually going to suspend a student, send them home, send them to ISS? What is it that we do for this kind of violation? Teachers should not make these individual decisions on their own. This should be something that you should involve campus administration in. Absolutely.
So what if the administrators refuse to enforce the mask mandate in any way in the district?
That, and I'll say we have seen situations where that has apparently been the case. And ultimately, especially regarding students, it's ultimately just like any student discipline issue. It's up to the administration, has kind of the final word as to what disciplinary consequences are going to be for a student's violation of any district mandate, whether it's masks or whether it's talking in class. So there isn't any one answer I can give to this, because these are all such locally controlled issues. The districts who are doing mask mandates in the first place, of course, are going against the Governor Abbott's order. Again, there's an argument that he didn't have the authority to give the order in the first place, so it's okay for them to do that, but they are going against the order. And so because they have made that individual local choice to do that, all of the choices that are related to that, like, okay, what are we going to do if somebody doesn't follow what it is we said they should do, are again going to be made locally. So you want to see what it is. I can't tell you that there is one thing that's going to happen if an individual administrator doesn't follow the district's mandate. It could be that they have been advised not to for legal reasons. Again, there's another flip side. There's an argument that the governor didn't have the authority to do the mask mandates. There's certainly an argument that the governor did have the authority. So it's possible that districts could, when it comes down to it, do the mask mandate, but be a little cautious about actually disciplining a student or a staff member for violating that, just because that would potentially increase at least the district's legal risk.
Okay, so now we're switching gears. The question submitted is from someone who's in a district that does not have a mask mandate. Can they incentivize students wearing masks with like extra credit or visits to the treasure chest or anything like that?
I would be very cautious in doing something like that. Number one, depends a lot on the age of the student. incentivizing things, that gets tricky, particularly with younger students. Do they understand the distinction between that? And I'll be honest with you, this is just such a hot button issue at this point that any action that a educator takes, particularly a teacher, but any educator takes to push a student, especially a student, one way or another is going to be risky. I mean, that's just, again, we've all seen the news stories, we've all seen the videos, and it is simply risky. So prior to taking any action that hasn't already been adopted by the district, of course, the districts can create incentives. Some districts have, I think we'll probably talk about that later. You want to run this by the administration to make sure that your campus administration, and they may want to take it up to the central administration themselves, are okay with whatever it is that you're doing. So if you do get that parent complaint, what are you doing? I don't want my kid wearing a mask, or they don't want to wear a mask, but they don't get their candy because they're not wearing a mask, or whatever it is, that you're not out on that limb by yourself.
Okay. Well, the next hot button issue that we got some questions on is the vaccine, of course, not surprising.
Yep, I knew that was going to come up.
Found out that the governor has called another special session for the 20th, and COVID-19 vaccine mandates are on the call. So that's going to be interesting. Barring whatever happens during the special session, can my district require me to get a COVID-19 vaccine?
The governor has also ordered in the latest let me try and rephrase that in English. In the latest order the Governor Abbott put out, he stated that individual government entities like school district cannot require vaccinations. As you may know, earlier orders had said they couldn't be required based on the fact that the vaccinations were being dispensed under an emergency order. They had not received full FDA approval. As I'm sure everyone knows at this point, some of the vaccines have received full FDA approval. Governor Abbott was very quick in putting out a new order saying that, okay, the prohibition and requiring vaccines apply to any vaccines, not just the ones under an emergency order. They apply to any of them. So again, like with masks, Governor Abbott has put out that order. Now, we haven't seen honestly any that I know of. We've heard some districts talking about requiring vaccines, just like a lot of districts have required masks, even though there was a governor's order prohibiting that. So it seems that districts are a little bit more cautious when it comes to vaccines than they were about requiring masks. We may see some that do require it. Whether they enforce the requirement or not sure. But again, because there is obviously a significant difference between requiring a vaccine, requiring a person to actually, get a medication put into their body, and wearing a mask, I'm not surprised that districts are being more cautious on this issue. But to go to the bottom line, I'm turning, have to use a lot of words to answer any question, but to go to the bottom line, at this point, we do have a governor's order that says districts cannot require staff to be vaccinated.
Okay. So going further down the line, can my district require me to tell them whether I've been vaccinated?
There is no prohibition on the district or any employer, and this actually goes back to just general employment law, from asking and requiring staff to share, whether with appropriate district individuals, whether they have been vaccinated or not. That appropriate district individuals is key here. There's a lot of information that you share with your district. There are people in the district who have access to your social security number. That doesn't mean everybody gets to see your social security number. Just like social security numbers, there are people who have access to your medical information and can have access to your medical information. That doesn't mean everybody gets to have access to your medical information, but it is generally understood in employment law that an employer can ask that, but they are required to keep that information confidential and limited only to those staff members that have a legitimate reason to know it.
Okay. Can a district give an incentive to be vaccinated?
That's a good question, and we are seeing a lot of this out there with a lot of these questions, because there are districts that are incentivizing vaccines, and the answer to that is yes. An employer, again, including a public school district, can incentivize this. Now, again, one thing a district needs to be careful about, and from what I have seen, the examples I've seen, the districts have been careful about this, is that whatever incentive that the district gives needs to take into account individuals who have a legitimate reason why they can't be, or legitimate legal reason, I should say, why they can't be vaccinated, either a health-related or religious-related reason. Again, the examples I've seen for districts that haven't had incentives have included something along the lines that if the individual can show that they have a health-related reason that they couldn't get the vaccine, or a religious-related reason that they couldn't get the vaccine, that incentive does not necessarily, they may be entitled to the incentive themselves. But if it is simply a choice, if it's simply a decision that individual has made that for whatever reason, I don't trust it, I wanted to see more testing, I wanted to go longer, whatever the reason is the individual has for not having a vaccine, if it isn't based on a doctor saying that because of a specific health condition you have, you honestly shouldn't get it, or again, it's hard to say, it's hard to use the right characterization for the religious exception, but for lack of a better term, and I'll say it like a lawyer, a legitimate religious exception. In other words, something that is actually in the religious tenets, or the tenets of the religion that you actually practice. Those can be exceptions, should be included in the local policies that provide for incentives. And again, like I've said, from what I've seen, the districts have been smart enough to do that.
Okay. Well, I feel like a lot of people are throwing around HIPAA violations these days. Is it legal for me to ask a colleague whether they've been vaccinated?
You can ask. I mean, honestly, you can ask. That doesn't, the colleague may get annoyed by you asking whether they're vaccinated. I mean, they're a colleague, and again, let me make sure I'm being very clear on the question I'm answering here. We're talking about colleagues. We're not talking about subordinates. We're not talking about anyone that you have managerial or supervisory authority over. We're talking about peers. We're talking about the teacher across the hall. In that case, sure, you could ask. Like I said before, they may get annoyed by a question. They may refuse to answer the question. They certainly can refuse to answer the question. My advice, and this isn't really legal advice, it's just practical advice, is because again, this is such a touchy subject, you should approach it with understanding of how touchy a subject it is. You know your coworkers better than I do. Is this something that is going to raise their hackles, or is it something that they're going to be more than happy to answer? I mean, on one level, it's no different than asking, what'd you do last weekend? That's also something they don't have to share with you if they don't want to. That's something that, again, does not have I'll use the same term again, hot button issues that whether you got the vaccine have at this point. So be aware, There is no prohibition in it, but it can be very touchy. Because it can be very touchy, it can lead to complaints. Again, it's not a legal violation for you simply to ask, but it doesn't mean that your peer can't go to your principal or assistant principal and say that they are feeling harassed by your question or something like that. That is the world we live in today.
Can I ask my students whether they've been vaccinated?
That one is far more touchy. The answer to that one, and again, because you're not a peer to your students, there's no one listening to this webinar that is a peer to a student. You are probably, most of the people listening to this are teachers. And as a teacher, your student sees you as an authority figure. I mean, you are an authority figure. You get to tell them whether the answers they give you on a daily basis are right and wrong. And if you say they're wrong, you get to grade them that way. So they see you in that way as an authority figure. That makes it much, much touchier to ask a student whether or not they are vaccinated. Now, I'll tell you, there's an easy, one thing, any teacher out there who has students younger than 12, you don't need to ask whether they've been vaccinated, of course. We know they haven't because the vaccines have not been released to children that young yet. But above that, my honest advice would be not to do it. Not that there is a specific legal prohibition, not that TEA has come out and said you can't do it, or Governor Abbott has come out and said that you don't do it. It's just simply too dangerous to do it. If you're thinking at all about possibly doing it, please, again, and I've shared this advice before, but it certainly applies here. Talk to your administrators about it first. You do not want your administrator hearing about this for the first time from a parent call, because the parent is upset that their student has come home and told them that you have asked whether they're vaccinated or not. But again, this is very different scenario than asking your peer across the hall whether they were vaccinated or not.
Okay. Well, we're hearing a lot of, switching gears a little bit, we're hearing a lot of reports of school districts that are either shutting down classrooms or taking classrooms remote, or grade levels remote, or campuses remote. So we have a few questions about that. Mm-hmm. I've heard the term remote conferencing. I hear some school districts are using that to temporarily go to remote learning to deal with COVID outbreaks. What does that mean?
Remote conferencing, yes, that's a term TEA came up with for this year. And it is a process whereby a student who cannot come to school, and it's limited, it's restricted in how it can be used. It's not a student who just doesn't want to come to school, or their parents are afraid to have them come to school because of a potential COVID outbreak. It's a student who can't come to school either because of a health reason, because they've actually tested positive for COVID, or because they're actually quarantining because of a possible close contact. In one of those cases, TEA has said that student can be taught remotely. There's a limit. They can be taught remotely for up to 20 days. The district can ask for a waiver to go beyond that, because TEA has said we recognize that a particular student might have multiple times that they have to quarantine. And so, they may not be able to come to school for more than 20 days over a particular school year. So a district does have an option for requesting a waiver to go beyond the 20 days, but the actual process that we're talking about with this conferencing is limited to 20 school days. But for that, again, it is possible. It is basically very similar to remote instruction that a lot of you dealt with last year. It can be individual, it can be by group. There are particular provisions as far as synchronous and asynchronous learning. Don't want to get into the details because that's actually something more for the district administrators to deal with, but that's basically what it is we're talking about. We're talking about a process whereby individual student who, for individual health reasons, cannot come to school, they can be taught remotely. And ultimately, want to distinguish this from what a lot of districts, or at least some districts, a lot's probably an overstatement, but some districts have done where they have just been providing remote instruction. The difference here is that for these students, the district actually does get its funding for the students. Because the difference, like Austin ISD actually is providing remote instruction for students and not receiving their money from TEA for that, because they're doing that on their own rather than through a program from TEA. This is one where the students' ADA actually does count. And so the district does get their full funding for the student.
Okay, interesting. I had seen some reports of school districts that had to shut down entirely or were cut, adding a couple days to the Labor Day holiday. Will that extend the school year in those cases?
That will depend on a couple of things. Number one, it's going to depend on what school calendar was in the first place. Did the district build some days into the calendar after the experience of last year so that we had some extra days to use? I mean, districts have always built some days into their calendar. There were the traditional bad weather days have always been there. Some districts may very well have built a few more days into their calendar. I've seen at least one example of a district that has modified some what were teacher work days back into instructional days to take care of days the district was going to be closed. So there's a few different ways that a district can handle that situation. But it is possible that a district can extend the school year. Now, again, that's going to depend on a number of different things. What the calendar is in the first place, and probably more importantly than anything else, what teachers' contracts say about changes to the school calendar. I will tell you that it has, for some number of years now, been pretty common for teacher and other certified administrators, certified educators that have contracts, for the contracts not to have a specific calendar referenced or stated in the contract, not have specific end day, beginning days and end days, but have some kind of general language that says you will work under the school calendar as it exists or may be amended for the school year by the school board. So if the contract provides the district with the ability to change the calendar, then to at least some extent, the calendar can be changed. Now, what the extent is one of those things lawyers can argue about. And really, it can come down to what lawyers can argue about. Is the change too much? There's some changes that I certainly would say would be too much, that an attorney that represented a school district would say, oh, that's perfectly reasonable. We don't always agree on things like that. But ultimately, for the document that's probably most important in terms of what a district can legally do as far as changing the calendar is the contracts it's given to its contract staff.
I'm guessing the contract is probably the answer to this next question. Can my district add extra duty to my schedule to cover staff shortages due to COVID?
And Kate, you are right. You have been reading my postings on the web and such. Yes, the contract is by far the most important document as far as that goes. I will say that I have been practicing this area. I've been with ATPE almost 25 years now. It'll be 25 years in January. And I have seen a lot of contracts over those years. And I have yet to see an educator's contract that does not have what we call an additional duties clause in it. And basically what that is, a paragraph that says that the district can reassign educator within professional capacity and can change or assign additional duties to that educator. Now, again, like I was saying with the contract or with the length of the school calendar. There is some limit as to what a district can do under the additional duties clause. What it comes down to really, there's two things that it comes down to. We do have some commissioners' decisions that I base this on. There's two things that govern what a district could do and say, well, look, it's in your contract. You agreed by signing your contract to additional duties. This is one of those additional duties. The first thing is whether it is the kind of duty that a teacher in general would just kind of understand that this is the kind of thing that teachers can be expected to do. The classic example of this is grading papers at home and grading papers on the weekend or working on your lesson plans on the weekend. Weekend is not one of your regular work days. 8 o'clock at night, 9 o'clock at night is not your regular work time, but there's probably no teacher listening to me here who has not been grading papers on weekends at 8 and 9 o'clock at night. Teachers understand that's part of the job. That's a good example of an additional duty that's just, again, it's understood that this is just the kind of thing that teachers do. Separate from that is where a teacher has some kind of specific knowledge that their district is going to expect some certain thing for them to do. We have a couple of cases. They're very old. They predate me even, where teachers had argued about they've been told that they had to man the concession stand for football games on Friday nights. Again, Friday night, not normal teaching hours. And they argued that, this was outside their normal contract hours and that they couldn't be required to do it. Well, it came down to the fact that the teachers knew. These teachers knew that teachers in the district that they were in were expected to man the concession stand during football games on Friday nights. So it was understood that, okay, that may not be the kind of thing like grading papers in the evening or working on lesson plans on the weekend, but you did know this. You knew this was possibly going to be an expectation of this job. So you agreed to it when you signed the contract. So I will tell you, there's a lot of gray area there. What is the reasonable expectation for a teacher? I know I said a moment ago, I've been working with teachers for 25 years now, and I will tell you the expectations on teachers have changed significantly over the last 25 years. Teachers 25 years ago were not expected to do what teachers are expected to do now. There has been an evolution there. How far that evolution has gone, whether a particular thing is a part of that evolution is something we can argue about. So just to give us a couple of specific examples that come up here. One would be, covering a class, for a teacher that's out and they ask you to cover a class. Covering classes is something teachers have done. I mean, that honestly is not that unusual. Now, covering a class during your required planning and prep time, that's different because, again, you have a legal right to your planning and prep time. So there isn't an understanding. There is no understanding that, well, teachers give up their planning and prep, legally required planning and prep time all the time, so you could be required to do that. So a lot of it's going to come down to specifics as to what it is the teacher is being asked to do in addition, whether or not that thing is kind of thing that teachers can be expected or to do, or whether or not that's the kind of thing that, whether it's based on what happened last year or something that was said back when the teacher had a choice of, oh, if that's going to be the case, I'm out of here. Back when they had choices to that, whether they were told that this was the kind of thing that could be expected.
So then this question may be a little too specific, but we have a question from someone who's a lead teacher. They've been assigned to do 4 hours of remote online learning on top of regular daily duties. what options do they have? They're working 2 to 3 hours over their regular schedule.
That is, and honestly, and that's a good example of a thing where I might very well disagree with a district attorney as to whether that's reasonable or not. Whether working that much, especially in instruction. Again, there's a difference between sitting at home in front of the TV with your feet up off the coffee table with papers to grade in your lap while Netflix is on and doing virtual instruction on Zoom like this. Those are two very different things. I would argue anyway. So I don't, that said, there was a lot of virtual instruction went on last year. And a lot of teachers working a lot of extra hours last year. Whether that was enough to put teachers on notice this year that, again, teaching has evolved to the point that teachers can expect to be working such hours. I would argue that's not the case, but I cannot say that that would be a unanimous decision on both sides of the bar, the attorneys that represent teachers like I do, and attorneys that represent school districts like some attorneys do.
We have a lot of questions, not surprisingly, about leave and quarantine. I think that's probably the where there's the most gray area right now. So first question, is there any type of leave available for COVID-19 related absences?
There's nothing specific. There's nothing generally specific, I should say. As probably or hopefully everybody knew, last year we had the FFCRA that did provide COVID-specific leave on a national basis. That law expired last December 31st. Now, since then, there are some districts that individually have adopted policies that provide COVID-specific leave. It is up to each individual district. It's basically the same as district sick leave. It's common. A lot of districts provide 5 days, and for the last 25 years that I've seen, almost every district provided 5 days of local sick leave. There were some districts that didn't provide any. There were some districts that provided 3. It was entirely a local decision as to what it is that they did. Same thing with COVID leave at this point now. Some districts are providing it. A lot of districts are not providing it. So it's possible that you may be in a district that provides some type of COVID leave, but if it is something that your individual district has adopted.
So the federal leave is gone.
The federal leave is gone.
Okay, we did have a question asking to clarify that. So related, if you've now used all of your state and local leave, do you get, is there any way to get compensation for the days off if you have to quarantine again?
The two things. I actually, and another thing I want to, in this answer, I want to make sure I'm very clear that we're talking about quarantining as opposed to being out because you are actually sick yourself. Because there is an important distinction that can be made there, particularly quarantining because of a close contact. You're not quarantining because you're sick, you're quarantining because of a close contact. Again, a change that has been made is that there is no requirement anymore for staff to quarantine because of a close contact. Last year, there was a requirement from TEA that, depending on the close contact, you had to quarantine for 10 days, that the guidance changed, but it was actually a requirement. There is no such requirement anymore. Now, the CDC has guidelines, the CDC has recommendations regarding quarantining, but it is not a requirement that individuals quarantine. Because school districts are not required to have their staff quarantine, there is an argument, anyway, that at least for staff who are employed under a contract, that if the district is going to tell them they have to quarantine, and again, this is because of a district choice. Again, no legal requirement. Again, They're not sick, because if you're sick, you're legally required to, district is legally required to have you stay home. If you're just quarantining because of a close contact, not legally required to quarantine. If you have a contract which gives you a legal right to go into work, and your district chooses to, for possibly very good reasons, but again, their choice, to have you stay home, they may very well, there's at least an argument that they should pay you for that. Because again, it's their choice to have you stay home as opposed to your choice for having to stay home. Now, I know I said it before, but I want to make sure I'm clear on this. This argument is at this point an argument. I have not seen this go through litigation, so I cannot say how well this argument would fare, number one. Number two, this argument is based on the existence of a contract. Again, it's a contract that gives you that legal right to have this job to go to. If you don't have the contract, you don't have that legal right that the contract creates. So this is something that would only apply to individuals that have employment contracts. But bottom line is, if you are quarantining because of a close contact, there is a basis in your contract for saying that the district should pay you for that without taking your leave. Again, cannot say that this is the law, because this isn't. This is basically a legal argument at this point. But it is a legal argument at this point. But for those who unfortunately don't have a contract and so don't have that legal argument there, district can basically say, we want you to stay home and we're not going to pay you other than just whatever leave is available under the local district leave policy. And of course, like I said, if you are actually ill, then they can certainly require you to take leave. You take your leave. And if you've exhausted your leave, unfortunately, the alternative then is unpaid leave.
Can a district require an educator to participate in staff meetings or training virtually while they are on COVID leave?
Let me want to make sure I'm clear here. If they're on COVID leave, we're talking about some locally created leave that there's no legal right to and district is just established. If that's the case, then it is possible that the district, as just one of the terms of the use of that leave, can be that we expect you to do X, Y, and Z. Again, that's not leave the district is required to provide at all, just like sick leave, they're not required to provide at all. So they can put specific terms on it. And again, using an example that's been around for sick leave for a long time, there are some districts that will provide X number of days of sick leave at your full rate of pay. And then they will provide extended sick leave at your full rate of pay minus whatever they pay a sub for. In other words, you're not getting your full rate of pay. You're getting part of your pay. Districts can do that because, again, there's no legal requirement that they provide this leave at all. So they can provide you, part of your pay with that leave. So with quote unquote COVID leave, because there is no such thing as COVID leave other than just what district has provided, they could create some kind of expectation that you will participate in X, Y, and Z to the extent that you can. Now, if we're not talking about COVID leave, we're talking about just some kind of leave. You're using your personal leave, you're using your sick leave, you're on family medical leave, something like that. No, the district should not be expecting you to perform any duties while you are working or while you are on leave. Leave is leave. Leave is leave from work. So they can't basically have you work while you're on leave. So a lot of districts are actually very conscientious about this and are very careful to make sure that people don't work while they're on leave, because it can honestly be an accounting nightmare if it comes back that turns out somebody did work, and then there's a question of, okay, how many hours count as leave and how many hours count as work hours, and it can be a mess. But That's the distinction that's important to make. COVID leave, it's possible as long as, then it should be stated in the policy. This shouldn't be an individual decision made by an individual principal or something like that. As long as it's actually in the policy that can be expected, then it can be expected. Other types of leave, like personal leave, sick leave, family medical leave, temporary disability leave, no, you should not be expected to work.
So we had a commenter say that they had seen on the TEA website that the federal program that you had described was extended to September 30th, 2021. I think we should probably clarify, Congress was the one that created the federal leave, correct?
Yeah, and basically what they did is they extended tax breaks.
Okay.
To if an employer chose to continue providing leave, they could continue getting tax breaks. But their requirement, what we had before December 31st was requirement for leave. And because of the nature of the business, the public school districts as a business entity, they don't get the tax breaks. So I have not seen any district that chose, and again, it was a choice to either continue to leave or not. And I haven't seen any district that continued COVID leave based on that. Again, some districts actually did, even last school year, even in the spring of 2021, actually did as a local policy, just like, you know, continuing it into this year, actually did provide COVID leave, but no, it was not the same requirement that they had prior to December 31st.
Can a district make COVID leave available to vaccinated employees, but not unvaccinated?
And that is another question we have been hearing a lot. The answer to that, and I kind of touched on it earlier, but the answer to that is yes, with one caveat that, again, the leave policy needs to take into account whether there was a health related or religious reason why the individual was not vaccinated. Just as a general rule, an employer can, including a school district, can incentivize getting vaccinated. There is no prohibition in that. They can provide some benefit to getting vaccinated that people who don't get vaccinated aren't eligible for. That is not the same as penalizing people who are not vaccinated. You know, not getting a benefit that didn't exist before is honestly not at least legally recognized as a penalty. So as long as they provide those exceptions for health or religion, yes, districts can incentivize, and we have seen a number of districts incentivizing COVID leave, like providing COVID leave only to individuals who can show that they're vaccinated. And a quick follow-up, again, I know we talked about it before, but as far as the proving that you are vaccinated, yes, they can ask you to prove that you are vaccinated. That information, again, it is health information, so it should be only shared with the appropriate individuals with school district. That there is no, oh, well, you can't ask me that, that's health related. There is no general rule along those lines.
So this is kind of a staffing shortage / leave question. Our district is having trouble finding subs to cover classes. And I know I've heard that a lot of subs are not comfortable subbing right now because of COVID. And the member goes on to say, it's hard to schedule a personal day and receive adequate class coverage. I've already had to cancel a personal day because there were no subs available. What are our rights when it comes to absences and making sure that our classes have adequate coverage when most of our subs are covering for COVID-related teacher absences?
And I can tell you, yes, I've heard this issue before. I've actually spoken to a few members on this myself. I can tell you it's ultimately going to come down to the individual district's leave policy, but I can share with you pretty much what the answer is going to be, because this is an issue where almost all districts have the same same leave policy. Your personal leave is categorized in one of two ways, either discretionary or non-discretionary leave. Non-discretionary leave is treated the same as sick leave, and it's non-discretionary. It's leave that you use not because you want to use it, but because you have to. And ultimately, that usually means because you're sick. And again, and most policies, if not every policy I've ever seen, actually refer to the old Texas Education Code sick leave law that predated the current personal leave law that actually provided when a person was eligible for sick leave for their own illness or illness of a close family member. That's non-discretionary leave. Separate from that is discretionary leave. And that is, like it sounds, leave that is taken because the educator wants to take it. They're not required to, they're not sick, they don't have a family member sick. There's just something they want to do. There's a graduation that they want to go to, or they just want to take some time off. Every district policy that I have seen, if you want to look it up, you will find it on your district's website somewhere. Usually if you go to the board section of the website, you'll find the board policies, and it is policy DEC local. You will see a provision where what I'm about to describe will be stated. That for discretionary leave, a district can restrict the use of that leave. They can't restrict it based on why it is the person wants to take the leave. They can't say, well, why is it you want to take it? Well, it's for graduation. Well, we'd let you take it if it was for a quilt show, but we're not going to let you take it if it's for a graduation. I was going to see if Kate was going to smile there, but she didn't. She likes quilt shows. Just share that secret with you. But they can't use it for, they can't use the reason for the leave to deny the request for leave. They can, however, use how the absence is going to affect the campus. They can use the staffing at the campus as a reason to deny the request. Again, it needs to say it in the policy, but I have not ever seen a policy that didn't say that. No, it's not something a principal can make up. But as long as the policy does have these restrictions in it for discretionary leave, a principal can say, I'm sorry, we cannot find a sub, or I'm sorry, our staffing just will not let people use discretionary leave. I've heard instances of principals telling teachers, don't ask. At the school first of the year, as a group, just telling them, don't ask for discretionary leave. I'm going to deny it this year. That's probably not appropriate, but honestly, as things have gone here, again, principal would need to be able to show that, yeah, there really are issues with staffing. There really are issues with giving a sub, but if they can show that, it is possible for them to deny a discretionary request for leave.
I feel like this is a very depressing webinar.
Yeah, that is true. That is true.
Does TEA have any social distancing guidelines, and should students be keeping social distance when they're in the cafeteria?
TEA is basically, at this point, TEA has basically said, everybody should do what the CDC says. But that's what they say, is everybody should do what the CDC says. They have, their guidelines went from, I don't know, whether it's 7 or 8 pages last year to about 1.5 pages this year. They don't require a whole lot. Now, they have made some changes at the beginning of the school year. They did not require that parents or staff members be notified if a student tested positive and there was a close contact. They now do require that. But that's pretty much the only real change that's been made. So they say, oh, everybody should be safe and everybody should follow the CDC guidelines. But as far as any kind of requirement or any kind of consequences, if it doesn't happen, TA has remained pretty silent on that so far this year.
So we do have a question about notification. The educator says they understand that districts in San Antonio we're supposed to be sending out a standard memo saying there'd been a positive student or staff member on campus. The school is not doing that, and it appears not alerting those in close contact that they might have been exposed. So is that an issue, a legal
Could be.
issue? Okay.
Yeah, no, certainly could be, because this is, again, they did recently change, and I cannot tell you at this point. I'd like to say it was like a couple of weeks ago that guidance from TEA changed, but that's off the top of my head, and I may not be having the time frame right. It has not been since the beginning of the school year. It's something that has been more recent than that, but yeah, that could definitely be an issue. They are supposed to be notifying at this point.
So this is an interesting question. What if you're on a local COVID lead and the district has no documentation on what the requirements or boundaries are for this? What if it is all up in the air?
Well, and that there should be some, number one, there should be something, because to have established some kind of local COVID leave that normally would have had to go through the school board, which would mean the school board would have had to have voted on something to establish this local COVID leave. Now, I will tell you, again, I've been working in this area for a long time, lived in Texas even longer, maybe some smaller school districts that have flown by the seat of the pants a little bit more than that, but really there should be something. Now, I will tell you from personal experience, it can be difficult sometimes to find that information. I know one not particularly small school district was looking at recently that took a long time to find out what it is the board had actually passed as far as COVID leave, because it wasn't on the website, wasn't in district policies yet, and was very difficult to find in the board paperwork. Did finally manage to do that, but it took some time, took some work to get to it. So it can be difficult, but there should be something there that says what the provisions for the leave are. But ultimately what it comes down to is, if there's a question about it, dealing with the administration. I will say, and this is related to this, the Texas Association of School Boards recently changed their guidance regarding leave policies to school districts. As some of you probably know, a lot of school districts depend on the Texas Association of School Boards to provide them with model policies, which they then adopt. It's up to the individual school district to adopt them. It's not automatic, but the Texas Association of School Boards, or TASB, as we call it, drafts these model policies. Well, back a few months ago, TASB decided to change their model leave policy. And their idea is that the model leave policy had too much detail in it. And they thought it would be better for it to be more general. And so they sent out a new model leave policy to the school districts saying, here's our new model leave policy. It's much more general, does not provide nearly as much information as our old one did. Now you need to go in and you need to develop local regulations to fill in for what we've taken out of this. And they made very strong recommendation in that case. They recognized, of course, that district had to do that, and not all districts were going to, especially in a timely manner. So it is very possible that there are districts out there that their leave, some of the very practical aspects, some of the nuts and bolts of their leave policy is based on sticky notes attached to somebody's monitor in the HR department. It's a depressing thought again, but that is very possible. And that is, I think, one thing that we're dealing with here is that what is put out in writing has been very much more than before left up to the individual school districts. And I think we've got a learning curve as far as that goes for districts to recognize that, number one, they need to do this, and number two, do it, and then number three, get it out to where people can actually see what it is that they've done. So we do know how the nuts and bolts work.
have time for a couple more questions. We do have some great other questions, and I know Paul can perhaps follow up with a blog post or additions to our FAQ page.
Very true.
One question that we got, what is kind of related, what can I do if my school does not want to close the class if 5 positive cases are in the class? So I guess one question would be, is there a threshold for going to remote conferencing or not?
No, there's no threshold, at least at this point. And, things may evolve. Things have evolved so far. And, like we were talking at the very beginning, back at the beginning of the school year, I don't think anyone expected that we would be where we are now, and things are very definitely still evolving. We see reports of entire school districts closing, campuses closing, and classes going remote daily. That may very well at some point lead to some more specific guidance or requirements from TEA than what we have so far. At this point, though, there is none. So it's up to each individual school district to decide what their local policy is going to be as far as quarantining, as far as going remote. Now, I mentioned it before, one of the issues districts deal with, of course, is funding. That at this point, there's very limited TEA funding for districts that go to remote instruction, which is a real issue for districts and real issue for educators, because of course, district has to have the money to pay the checks. So we're hoping that as this situation continues to evolve in a not positive way, that those in Austin are taking note and will deal with the situation. I did see that Governor Abbott has called a 3rd special session. He has put on the agenda vaccines anyway. Now, again, it's not going to deal with school district issues and when classes are going to close and when they can go remote and safety and all of that. But hopefully at some point we will get, if not more guidance, at least more flexibility from TEA, allowing school districts to make local decisions that are best for a local school district without having to worry about the financial consequences of it.
Okay. I think we are out of time. Unfortunately, we have had some fantastic questions. Thank you everyone for attending.